From the main list, item number 1.
Who's for the appellant?
Mr. Saraf, video.
You're for the appellant?
We are for the appellants.
You're for the appellant?
Yes.
Yes. What is the matter about?
Worship, this is a matter regarding fuel supply agreement
My lord,
executed with coal India by the other party. The condition there was...
Yes, Dr. Saraf?
my lord, in fact, I had some difficulty because yesterday night only, my lord, in fact, I missed the item. And since you
Tell us.
against me,
Because
I need to...
you're Mr. Ahmed.
Yes.
Mr. Ahmed has also come from, where have you come from? Guwahati. So both of you fight it out and tell us a date. We'll
22nd or 29th.
22nd.
It is convenient for worship in the 22nd or 29th.
22nd and 29th. 22nd we fix the arbitration matters. 29th?
29th.
Very well.
29th also, my lord.
29th?
My lord.
Very well. At the request of the parties, let the appeal appear on May 29th.
I'm sorry to Mr. Milord.
That's all right.
Ahmed, he has come down.
That's all. One matter. Same matter. Same order in the other matter.
My lord.
Mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
Yes.
Please, my lords.
Before it starts, my lord, I am representing only Union of India, my lord, which is only a former party here. The main contesting party is United India Insurance, my lord. It appears that he is not. So,
No, actually, on 226, the advocate has informed that he is not the standing counsel, my lords.
Therefore, you've got
So he has to get the orders from the court.
You have to serve them. The applicant will serve all the respondents other than the union and file an affidavit of service. Paragraph, the matter will appear 10 days hence.
My lords, permission to serve it to the advocate, my lords.
No. Advocate, if he does not have authority, how can you serve an advocate?
No, on that advocate, my lords.
No, certainly not. You have to serve direct to the parties.
Yes, my lords.
How will you know whether advocate has authority or not?
Yes, my lords. And there is a delay of 23 days in filing the appeal.
Not in their absence, only in their presence.
Yes, my lords.
Item number 2.
We'll take it at the end of the board.
number 2.
From the main list, item number 1.
This is that felling of tree or construction of that flyover.
Flyover and the road, Your
How
Lordship.
are we doing, Mr. Khan?
Lordship, just yesterday evening, we have received the Google Sheet status report as on 8/5/2023.
Yes.
So, Your Lordship, we would like to, because some portion we are just going through it, Lordship, some portion is not legible. So, we would like to bring it, Lordship, kindly, for a week, we will try to bring it on record. And, Your Lordship, would like to inform.
Because some trees have already been cut.
Lordship.
And as Mr. Paul had indicated, that sometimes these projects are ultimately never completed, but the trees are cut nonetheless.
Absolutely, Lordship.
So we'll have to justify the felling. We also did not injunct you.
Lordship.
Because this was
Absolutely.
a public project, we did not injunct you. So therefore, the project has to be there. It's not as if the trees are cut, now let's forget about the project.
Absolutely. Lordship, in fact, after the last order on 28 March, I myself had gone for the meeting, Lordship. There was
And
two
Mr.
meetings.
Khan, there's something else completely unrelated.
Lordship.
Completely unrelated. You see, one of the things that is post-COVID, you have a lot of tourism which is happening. You're promoting tourism. God bless you for that. Because that also earns revenue, that gives some employment opportunities to our local population over here. But some of the water bodies need to be protected. And in one of the matters, we will make an order, and that's why we are telling you in advance that nowadays you'd find, I had made the order first in Chennai for drone photography and satellite mapping of water bodies.
Lordship.
You do it twice a year, one in the peak dry season, one in the peak wet season. And you get those pictures. And those pictures are maintained. Otherwise, in many parts of the rest of the country, what has happened is, I can talk about Calcutta from where I am,
Lordship.
that when we were young, we've seen water bodies, running into acres. And 20 years later, we see not even a small tank or pond over there. And in fact, in respect of one of them, I had found out that the corporation records from 1958 show that it was dry land. Whereas for 15 years, when we were growing up, we've seen that as a water body. So that these water bodies do not mysteriously evaporate,
Absolutely correct.
do not fall prey to land sharks.
Absolutely correct.
You have to map these water bodies, get satellite images and use drone photography and satellite images. You'll get the extent of that, and that will be kept filed so that in future, when an issue arises, whether this is a water body or not, you have records to show that at least in 2023, these were water bodies.
Absolutely.
Because under all town and country planning acts, water bodies cannot be constructed upon unless there are certain exigencies and certain, very onerous conditions on which you can construct. This is something you have to do to save the state, because once you get development with the level of construction that is happening all around, with the highways coming up, you see these dugouts all around the highways.
Absolutely.
And with tourism increasing, there'll be demand for more resorts to be set up. Hopefully business will come. So, there will be a pressure on land. And unless and until you have, a kind of map for a record of what is of now, you'll find 10 years later all your water bodies disappearing and people telling you there never was a water body over here.
Yes, certainly, Your Lordship. We'll confirm today. We'll convey.
If you can do it independently without any court order, it's most welcome.
Absolutely, Lordship. We'll.
The streams around here. When we were young, we used to see big streams. Now they are hardly drained.
Yes, that's why we are saying using water bodies in the larger sense, not stagnant water bodies, flowing water bodies also.
Lordship will convey. Absolutely.
Yes, Mr. Pal, are you there?
My Lord, I'm appearing for him today, my Lord. He's
Yes,
slightly...
they need some time to indicate the progress, so we'll give them a week's time.
Lordship, yes. We have the status report, Lordship. Only thing, it's not legible, so
Since Mr. Khan seeks some time on behalf of the state to file a status report on the progress of the Shillong-Dowki Road, particularly the proposed flyover from Rilbong to Jalupara, let the matter appear 10 days hence, full stop. Paragraph, a copy of the status report should be reached to the petitioner a day before the matter appears in court.
Obliged.
Item number 2.
Criminal appeal, you're ready with the matter? We'll proceed with the appeal.
Yes, my lord.
We'll take it after the tax matter.
My lord.
Because Dr. Saraf is waiting, we'll take it after the tax.
My lord.
Yes.
Item number 4.
Lordship, the paper book was made over to me yesterday only.
Very well. Since it is submitted on behalf of the respondent that the paper book was made available only yesterday, let the appeal stand over for a fortnight.
Lordship. First place, Lordship.
Second call from supplementary list. Item number 2.
Before Mr. Dr. Majika gives the reply,
Yes.
may I place one more provision, if you lost it, just
Several. We'll give you a chance to place several provisions. Before that, just clear my ignorance on some aspects, please.
No, madam.
No. The first is that if a person does not file a return under 139, and it is discovered that he was liable to, then what can the assessing officer or the department do about it?
My lord, either 142(1), and if the time limit expires, then 147.
Now, 142(1) does 142(1) provide for the department or the assessing officer to call for a return to be filed? It only provides for any inquiry or investigation that the assessing officer may deem fit to be conducted.
Just see, no? Right.
Subject to correction,
My lord.
I think that it empowers anyone to call for a return to be filed when a person has not filed a return.
My lord.
Give us the Income Tax Act.
My lord, see, Mr. 142(1), 1, my lord, clause 1.
142(1). One will not file a return.
Within the time allowed, under subsection 1 of
Subsection 1 is that he has not filed a return.
My lord.
And there's nothing. 1, 2, 3 are different situations.
My lord.
1, 2, 3 are different situations. Then you come to the provisos, and then you come to substantive provision, which is 2. For the purpose of obtaining, there is no authority. I do not find, subject to correction, that 142 empowers the assessing officer to say, no, you should have filed a return, file a return. 142 gives the assessing officer, for the purpose of, in respect of income or loss, may make such inquiry as he considers necessary.
Well, if lordship is just similar, 142(1), 1, my lord.
142(1), where such a person has not made a return
within the time allowed under section 1 of section 139 or before the end of the relevant assessment
to furnish a return of his income
or income by way of other person respective which is assessable under the act in the prescribed form.
Just a second.
So,
just a second. For the purpose of making an assessment under this act, may serve person who has made a return or in case time allowed for furnishing return required, wherein on a date to be therein specified, not paid a return, to furnish a return or the income of any prescribed prescribed. It says notice has been served and this is all. So 1 covers where he has not made a return, to furnish a return. And 2 and 3 are when he has filed a return and then furnish information. Yes, that is number 1. Number 2 is under section 1026, exemption pertains to 2 aspects. Income accruing to a member of a scheduled tribe in an area notified. That area, I may be a scheduled tribe in Mizoram, but if my income accrues from Meghalaya, I will still be covered by it because the wording of the section is very clear. The first part is, that is it. The second part is income, dividend and income for an interest on securities.
My lord.
Now, dividend, as we know, is dividend what comes from a company. Will interest on securities cover income from mutual fund?
I will submit it to you, my lord. If the investment has been made by a person from a scheduled area, like the tribal person from the scheduled area makes an investment,
Yes.
the income may come from any place, my lord, but the income will be said to be accruing or arising within the area itself. Now, in that connection, my lord, there is a judgment of the Guwahati High Court also, where, my lord, the supplies were made or construction were made to the outside the scheduled area, and the income was arising from that area. The court held, my lord, that any income, the process where the scheduled area starts, then where from the income is arising, that is not material, but it will be said to be accruing or arising within the area. Now, I am, my lord, making a investment in the shares, like from the scheduled area, from my income. Now, the income from there, the company is from outside, like in Bombay, is sending the dividend to me. So
Now, Dr. Saraf, if you come to 1026, just let's come to 1026. Why will it then specifically make a special provision for dividend and interest on securities? Then it was unnecessary.
Just, my lord.
My lord, the dividend and interest income, my lord, has been mentioned separately. In those cases, my lord, the factor where it arises is not relevant, my lord. From where the interest is accruing, my lord, or from where he is getting the dividend.
Exactly.
That's not relevant, my lord.
That's not relevant, my lord. So therefore, you can't take.
Even if I am getting interest from Maharashtra, my lord, I will be entitled to exemption, my lord.
Exactly. My lord. That's why it's been kept in a separate category.
My lord.
That's why it's been kept in a separate category. But interest on securities does not cover income from mutual funds. And will income from mutual funds be deemed to be covered by income in the scheduled area?
My lord, in my humble submission, mutual fund has two components, my lord. What happens, my lord, mutual fund ultimately invests in equities only, my lord, in the share market. So mutual funds also get some dividend from the company, my lord. But that is only a small portion of the income of mutual fund. Mutual funds mainly thrive on the price appreciation of
fluctuation of the price.
My lord. So that, in my humble submission, is not the income, my lord.
That is not
a dividend income, my lord.
That's not a dividend income.
That's an increase in the price, in the intrinsic value of the share itself, my lord.
So that's why you have capital gains.
Capital gains.
That's why you have capital gains, and that's why you have short-term capital gains.
Short-term and long-term.
But if I am a tribal, I'm investing in mutual funds. I've never moved out of Shillong. I'm a tribal in Shillong, and I invest in mutual funds, and I generate a lot of income. Will that income be exempt?
In my humble submission, it will not be, my lord. It is not dividend on securities.
But it will be covered by the previous one. Which is it will be part of his total income.
Yes, my lord.
It will be part of his total income.
Part of his total income.
So therefore, it can be covered by the first limb, which is any income.
My lord.
Plus, he's citing Guwahati. Let's even without that.
My lord.
That should be deemed to have been income accruing within a scheduled area.
My lord.
And so it will be covered by that one.
My lord.
But as far as dividend and interest on securities is concerned, it's a separate thing which is specially made.
My lord.
Because dividend accrues on at the place of the registered office of the company by operation of law.
Yes.
Therefore, so that it's not treated as taxable income, it is
no territorial nexus with that, my lord. That can arise anywhere, still they are entitled to exemption.
Because your initial notice,
my lord,
was issued under 147.
My lord.
And in that 147 notice, you referred to mutual funds, 30 lakh or something.
7 crores something, my lord. 7 crores something.
7 crores or something.
My lord.
And deposits in bank account.
My lord.
Now, that is not reason to believe. Reason to believe is something more. The fact that I've had transactions of 100 crore may not by itself imply that, I ought to have paid tax. Reason to believe has to have nexus with income has escaped assessment.
My lord.
Now, if you do not indicate how income has escaped assessment, reason to believe does not have any legs to stand on.
My lord, in my humble submission, the reason to believe came because if I'm supposing I'm depositing 20 crore rupees in my bank account, my lord, there must be some source of income for that. Now, what is that source of income, my lord? From there it arrives.
One is to call for a return under 142(1) and then look into it. And you call for a return, why? You will not call for a return from everybody. When you're calling for some return, must be that you have some information which leads you to believe that he ought to have paid tax. But reason to believe is something different. Reason to believe means that prima facie you are satisfied that some income has escaped assessment. Whereas a notice under 142(1), you just want to check whether it has or not. But 147 requires something more than 142(1).
Recording of reasons, my lord.
Recording of reasons, that's why it has to go to a senior. Now you are over here, that first step appears to be wrong. You could have initiated the thing under 142(1).
My lord, on that aspect,
but of course there is delay.
My lord, on that aspect, the Chief Commissioner, I try to understand from him. If Lordship permits, he wants to address on the difference between 142 and 147,
yes,
148.
Certainly. In fact, I have half a mind, Dr. Saraf, to request some of us to explain it to us.
Absolutely, Milord. I will also, Milord, be getting that.
Yes.
The Chief Commissioner.
Yes. Please go ahead. What is your name, sir?
Your Honor, I am Ambaredar Kumar, Chief Commissioner of Income Tax.
Mr. Kumar.
Yes, Your Honor.
Very well.
Your Honor, 142(1) prescribed in the Act empowers the department to call for a return, where 139(1) time provided under section 139 is over. But 139(1) has two legs, A and B. A says company and firm, they are required mandatorily to file the return of income every year, irrespective of the amount and quantum of loss and the income earned during the year. There, if the time 139(1) is lapsed, then 142(1) is required to be issued, asking the assessee to file return of income. But here, the assessee, the taxpayer in question, has never been filing return of income, has never filed return of income. Thereby, we do not know whether the assessee has a returnable income or not. Thereby, 142(1) cannot be considered in such circumstances where the assessee has never filed return of income before.
Why not, sir? Let's read the word.
Yes, sir.
And exclude that possibility. Let's read the wording.
Yes, sir.
Because we can't do anything more than what the plain words say.
Sir. (142)(1), Your Honor.
Yes, carry on.
For the purpose of making an assessment under this Act, the assessing officer may serve on any person who has made a return May I have a retention, Your Honor? On any person who has made a return under section 139 or in which case time allowed under section 139.
Oh, you're reading that into it.
Yes, sir.
So therefore, what you're saying is that clause 1
Yes, sir.
of subsection 1 will apply in conjunction with subsection 1.
Yes, sir.
Subsection 1 says that who has made a return, which means who has previously made a return, but has subsequently not made a return for the relevant year.
Yes, sir.
It would be applicable only to him.
Yes, sir.
But to assess to a person not covered by A, not a company or a firm, who has never made a return,
Yes, sir.
I will not apply.
Yes, sir.
Yeah, that's reasonable. Yes, go on.
So this, that is why now this 141 ceases in the case of the question of taxpayer, which is under consideration, Your Honor. Here, the assessing officer was in possession of information on which he comes to the conclusion and satisfaction that the income has escaped assessment. That is why the proceedings has been started under notice under section 148.
Now here, please come to, let's not do it in abstract, let's take what you say
Yes, Your
in your notice, because it has to be assessed. As you know, reason to believe has been judicially interpreted.
Yes, Your Honor.
You know, every year it's done probably thousands of times.
Yes, Your Honor.
Now, what have you said? Your allegation, if you come to
Page number
any of the orders, 38 or something.
38, page number 38.
My lord, there is one aspect, my lord. This recording of reason has been done away with in the recent amendment, my lord. This is not required any further, my lord. But at the relevant point of time.
Yeah, we have to go by what was necessary at that point of time.
Yes, at the time.
If you come to page 37, 38 quotes it.
Page number 38, Your Honor.
No income was filed. Information gathered reveals SSC had paid 775 for mutual fund, a high value banking deposit of 30 crore totaling 8 crore, 30 lakh totaling 8 crore. Has not filed return. I have reason to believe. Now it does not follow. Reason to believe, as we had said, has to have nexus with has escaped assessment.
Yes, Your Honor.
Merely because I earn 2 paisa and another person earns 2 crore rupees does not mean that the person earning 2 crore rupees has not paid tax where he was liable to. Reason to believe has to be something better than you have so much income.
Yes, Your Honor. The various High Court, because 148 has been the most litigant section.
Absolutely. There is only one way that can happen, and one way that can happen, and which I had indicated to Dr. Saraf, and that we will do after consideration. And that is that a degree of latitude may be given
Yes, Your Honor.
in interpreting reason to believe
Yes, sir.
in a situation where no return has been filed than in a situation where
Returns
it has
have been-
already been assessed.
Yes, Your Honor.
So there are 3 words used in 147.
Yes, sir.
Assessment, reassessment
And recomputation.
computation.
Recomputation. Yes, sir.
Now, assessment, forget assessment, reassessment and computation presupposes previous activity of such nature having been done.
Yes, sir.
Assessment implies this was never done. And so when it amounts to assessment, the reason to believe should be much more liberally read other than when it applies to a reassessment or recomputation.
Yes.
That is a possible argument we had indicated to Dr. Saraf, subject to, because frankly speaking, I don't, because this is a 6th schedule state, my learned brother also will not have that experience, and I really don't.
Your Honor, I am here standing for the facilitator as a facilitator.
Yes.
Yes, Your Honor. Yes, sir, Your Honor, it's very right. When the returns are not filed, then the consideration may be different. And when the returns are filed, even if I am in a possession of the information, prima facie, it has to be first inquired, verified from the return of income. The information which is in my possession is considered while filing the return of income or not. If it is not, then only it empowers me to go ahead with the proceedings of issuing notice under section 148. That is a prima facie requirement.
And then you require a return to be filed.
Yes.
In this case,
when notice
return was not filed.
In this case, return has never been filed.
Never been filed?
Yes, sir.
They also said that we have no accounts. We have not maintained accounts. And ultimately, details of bank accounts were furnished. And on the basis of bank accounts, you come to a conclusion that we'll go to the merits slightly later. First and foremost, to even enter the matter,
yes, sir,
we have to go into the distinction between reason to believe in case of non-filing of return and reason to believe otherwise.
Your Honor, if I am allowed to place, Your Honor, the SSC was having the option to file return of income under section 139(1). If that time is expired, the SSC still has been given the time under section 139(4) extended period for the end of the relevant assessment year. That also was not filed. when the assessee was given opportunity under section 148 notice to file return of income.
138 notice was issued.
148.
148, yes.
Then also the assessee has decided not to file return of income. Then after that, notice under section 142 was issued to the assessee to file. Then also he did not bother to file return of income. Matter does not rest here, Your Honor. If the assessment is passed, and if he has come to the knowledge that the assessment order has been passed, raising this much of demand against me, he has the option to file appeal against that assessment order. He did not file, Your Honor.
Against the 143 order.
Against the 143 or 148, 147 order, Your Honor. Then after appeal, he misses the file, he chooses not to file appeal. Then there is an option to file appeal with condonation of delay.
These aspects, I think Dr. Muzika will. We just want
I'm just
to
placing, Your Honor, before.
These aspects, Dr. Muzika will.
Then other option was also there to file 264.
Yes.
That's a 264.
Division.
260. Yes, Your Honor. That also assessee chose not to file. Then, Your Honor, then another option would be given to the assessee. There are many platforms, many exemptions, many relaxations has been 119(2)(b), filing return of income with the condonation of delay. That also they have not chosen. And then probably my assessee, my taxpayer, honorable taxpayer has been, my brother, learned brother has not advised him properly, and he has come straightway to the writ petition to Your Honor.
We are on the provisions of this.
Yes, sir.
Yes, very
Yes,
well.
sir.
Thank you.
When?
Be here, we'll call upon you just to clarify.
Yes, sir.
Yes, sir.
My lord.
The alternative remedy argument we'll deal with later. We are first on the basis.
My lord.
Yes.
My lord, first of all, with due respect to the Chief Commissioner, my lord, with my limited knowledge, my lord, the Learned Chief Commissioner said, my lord, that he has not filed the return under section 139 first. Thereafter, he said, my lord, that he could have filed under section 139(4) also the return, but he has not filed. Now, Your Lordship may kindly see section 139(4)(c).
Yes.
Well, every research and association referred to in clause 21 of section 10, Your Lordship, kindly, and similarly, my lord, from B to G, these are all different subclauses of section 10.
Yes.
Now, same 26 is not there.
Yes.
In these clauses. Now, it says, my lord, thereafter, shall, if the total income in respect of which so-and-so, all the person funds, so-and-so, they all have been repeated, venture, is accessible without giving effect to the provisions of section 10, exceeds the maximum amount which is not chargeable to income tax, furnish the return of income in the previous year in the prescribed form and specify the prescribed manner setting for such particulars as may be so. So, in respect of certain incomes which are specified into certain clauses of section 10, wherein section 10(26) is not included, it is provided that if his income, without taking into consideration the exemption of section 10 of the Act,
Yes, go on.
Is without giving effect to the provision section 10 exceeds the maximum amount which is not chargeable to income tax, shall file a return. So when the legislature has made a specific provision, then out of the different clauses, different incomes which are exempted under section 10 of the Act, certain categories of income which are exempted if their income, without giving effect to Section 10, exceeds the amount which is not chargeable to income tax, then he must file the return. Meaning thereby, my lord, that in respect to the incomes not specified in Section 4C of the Income Tax Act, a person, if after consideration of Section 10, his income has not exceeded the income not liable to tax, he is not required to file the income tax return.
This, begs the fundamental question that we've been repeating over and over again.
My lord.
That is the SSE the only judge of whether he is accessible to income tax?
My lord, with due
I
respect,
say that my income is not chargeable to tax, and that becomes gospel truth.
Well, with due respect to your lordship, my lord, I submit, my lord, your lordship is actually correct. I submitted on the last occasion also, on the last day also, that your lordship is raising the query, and the question which is coming to your lordship's mind is also, well, it came to my mind also, that how the assessing officer will determine, or how we will determine. But when the legislature by Section 4C has deliberately and intentionally, my lord, included certain incomes which are under Section 10 of the Act. Like various incomes are there. You'll also see the incomes which have been specified.
Dr. Saraf, let's not forget 139 4C. 139 obliges anyone whose income, total income, would be chargeable to tax to file a return. It obliges everybody. Loosely speaking. Loosely speaking. But since the word total income has been used, in accordance with the definition of total income and the exemption granted by the various provisions of Section 10, when your total income is exempted, then you need not file a return by virtue of the definition of total income. Well, 10 4C and 7 of the other provisions provide that irrespective of Section 10, without taking Section 10 into consideration, if your total income exceeds what would be not chargeable to tax, irrespective of the exemption granted under 10, you must file a return.
Yes,
it does not follow from there that those whose total income, those who may be liable to pay tax, but who interpret the exemption to apply totally to them, are exempt from filing any return. It does not follow. 4C only makes an exception to the general persons covered by Section 10. Certain categories of persons falling under the various exemption provisions in Section 10 have to file a return irrespective. We get the point that the ordinary person covered by 1026 does not have to file a return.
Well, I am asking a question myself, my lord. That Section 4C would not have been there in the statute book, my lord. If assuming 4C is not there. Now, if 4C is not there,
yes,
then whatever categories are mentioned in Section 4C, subsection 4C, my lord, they are not liable to file any return of income.
Absolutely. Agreed.
So, only because of 4C, the persons, although exempted in the Section 10 of the Income Tax Act, and because their total income after taking into consideration Section 10 will not exceed the
threshold,
chargeable threshold limit, have been directed that you file the return. Now, if the Section 4C specifically says that these 10 persons only, after taking into consideration, without taking into consideration Section 10, if their income is above the income chargeable to tax, are liable to pay tax return, then, my lord, the natural inference or interpretation which we give to, my lord, a provision of this section.
Very well. We follow your argument. We have a question for you. We have a question for you. It may appear silly, but please indulge us.
No, my lord.
No. Just. Let us say I am a tribal. I'm covered by 1026.
My lord.
But I also have income from other sources. I have real estate business in, let us say, Delhi.
My lord.
All right? And all of that I club together falsely.
My lord.
I say that I'm not filing a return.
My lord.
What is the remedy of the department?
Well, I will, my lord, similarly, if your lordship permit me, my lord, I myself is thinking of a case, my lord, that my income is 10 crores.
Congratulations.
But
don't understate that. Don't understate your income. Yes.
Exemption limit is 2,50,000.
Yes.
I don't file a return. Although my income is 10 crores.
Very good.
Now naturally a question may come that I say that my income is below 2,50,000. So I don't file the return. Now a question may come that how the assessing officer will come to know that if you don't file the return, because your income is 10 crores or so, you must file the return and make the statement. That is not the provision of 139. 139 says on the SSC that if the SSC's income, according to me, if the income is below the threshold limit of exemption, I am not required to file the return. Thereafter, you'll ask me see 142 once again. Well, the Chief Commissioner also read it, my lord. I may read it once again, my lord.
Yes.
My lord.
Yes.
For the purpose of making an assessment under the Act, the assessing officer may serve on any person who has made a return under section so-and-so or section 139. So first, a person who has submitted a return, or in whose case the time allowed under subsection 1 of section 39 for furnishing the return has expired. That means, my lord, a person who has not filed the return under section 139(1). Now, assuming in the case, my lord, I treat myself to be below the threshold limit, I have not filed the return under 139(1). 139(1) return is to be filed, I have not filed. Then what the assessing officer will do, a notice requiring him on the date specified therein, where such person has made a return within the time allowed under subsection 1 of section 39, or before the relevant assessment year, to furnish a return of his income or the income of such person in respect of which he is accessible under the Act in the prescribed form, prescribed manner, and setting for such other particulars as may be prescribed therein. So, a person, first of all, there is two categories, my lord. A person who has, may serve a person who has filed a return, and another person who, before the expiry of the period limitation, has not.
Your simple argument is that or is disjunctive over there.
My lord.
The or is disjunctive.
Because, my lord, it said before the expiry, like before the expiry of the limitation, one cannot issue a notice in the 142(1). So, if the period has expired, then only the power is conferred on the assessing officer that he may issue a notice under section 142(1) to directing him to furnish the return. So it is not that only in the cases where the SSC has filed the return. No. It's both.
Is there any limitation?
Well, in 142(1), I have not come. Chief Commissioner may say I have not come across, my lord, any limitation. But my lord, the limitation which is there, your lordship is aware, my lord, for the purpose of scrutiny assessment,
For the purpose of?
The assessment when I file the return, then within 1 year, either the return is accepted as it is, or 143 2 notice is issued for making a verification or scrutiny of the assessment. Now, if that notice is not issued, then whatever return is submitted, that is accepted.
Deemed
acceptable. Now, you also have seen section 147. A person who has not filed the return also, my lord, the reopening notice, escapement notice may be issued. Now, there is also a time limit for completion of initiating the proceeding for reassessment. Now, if those time limit has expired, then 142(1) also, notice also, in my humble submission, cannot be issued. Because, my lord, if the time limit for making the reassessment has expired, the question of issuance of under notice and for production of the books of account, because it is for the purpose of assessment. Now, if the assessment cannot be completed, the question of making the assessment does not arise. Secondly, my lord, in my humble submission, my lord, as your lordship is aware, my lord, section 147, proceedings can be undertaken only when some information has come to the possession of the assessing officer that certain income has escaped assessment. Now, by issuing a notice under 142(1), the assessing officer cannot ask me to produce the books of account, and from the books of account to determine that whether income has escaped assessment or not. That is not permissible under the Act. Once the assessment is become completed, but that is deemed assessment is completed without scrutiny, then only option is 147, and 147 is only when you'll also see 147, 148 once again, what the time will be, 148.
This is the new 148.
New one. Before making assessment, reassessment, or recomputation under section 147, so it includes assessment, Milo, and subject to the provisions of 148A, the assessing officer shall serve assessor notice along with a copy of the order passed, if required under section 148A, requiring him to furnish within such periods and so also return, etc. Now, also we see the proviso now. Provided that no notice under these sections shall be issued unless there is information with the assessing officer which suggests that the income chargeable to tax has escaped assessment in the case of the assessee for the relevant assessment, and assessee has obtained so and so. So, the notice under section 148, even for the purpose of assessment, that means a person who has not filed a return, no assessment has been completed. There also, the notice can be issued only when the information is in possession of the assessing officer that certain income has escaped assessment. Now, your lordship is well aware, my lord, that on the basis of, otherwise, my lord, what will happen? That if interpretation, my lord, that 142 notice, my books of accounts have been actually produced from the books of accounts are verified, and from there he again finds out that this income has escaped assessment. The very object and purpose of section 148 and forming an opinion that from your also that has it suggests that there is information with the assessing officer. Now, information cannot be by scrutiny of the books of account. Information cannot be by the production of the books of account and assessment officer. Otherwise, my lord, the scrutiny assessment under 143(2) will become nugatory. 143(2), my lord, gives a time limit for production of the books of account for the purpose of assessment. 143(1) return is, my lord, automatically accepted. Intimation is there. If the assessing officer feels that no, he wants to scrutinize the return, he has to issue notice under 143.2, and thereafter 143.3, he has to make the assessment. If he does not issue the notice under 143.2 for directing me the produce books of account, documents, etc., then 143.1 is completed. If 142.1 can be issued at any time, even after the expiry of the scrutiny period, then 142.2 and 3 will become nugatory. Because the assessing officer can issue a notice to me on 142.1 anytime you produce the books of account. If losses is 142.2, one second, my lord, for guided, 143.2, my lord. I may start with 1 minute.
Yes.
Where return has been made under section 139 or in response to the notice under section 1 of section 142, such returns shall be processed in the following manner. So, my lord, if the return has been filed under section 139 or a return has been filed in pursuance to section 142.1, then the process which is prescribed in section 143 has to be followed. Now 143, 1A, you will also see, the total income or loss shall be computed after making the following adjustments. Now, as the lordship is aware, 143.1A has been interpreted by the Apex Court also, that this is a prima facie adjustment which apparently, like my lord, I have claimed the LIC, HTC, my lord, deduction 2 lakh rupees. Although, as per the Act itself, it is 1 lakh rupees only. So, no verification is necessary. So, these prima facie adjustments can be made without issuing any notice to the assessee. Now, we'll also see 2, my lord. Subsequent 2, my lord. May I read, my lord?
Yes.
Where a return has been furnished under section 139 or in response to a notice under subsection 1 of section 142, the assessing officer or the prescribed income tax authority, as the case may be, if considers it necessary or expedient to ensure that the assessee has not understated the income or has not computed excessive loss or has not underpaid the tax in a manner, shall serve in the assessee a notice requiring him on the date to be specified therein, either to attend the office of the assessing officer or to produce or cause to produce before the assessing officer or any evidence on which the assessee may rely in support of the return. So, my lord, if the 142.1 direction is issued to issue the notice for submission of the return, then 143 process will start. 143 process will start, and if that return basis 143.1 adjustment is made over, if the assessing officer feels that no, I am not satisfied, I want to verify, then 142 notice is to issue, and thereafter you will also see 3. On the day specified in the notice issued thereafter, subsection 2, or as soon as thereafter, after hearing the evidence as the assessee may produce, and after taking into consideration all the relevant materials which he has gathered, the assessing officer shall by order in writing make an assessment of a total income or loss of the assessee and determine the sum payable by him or refund of an check so and so. So, after 142(1), if a notice is issued for submission of the return, then automatically 143 will come into operation, and either the return will be accepted as it is by making prima facie adjustment, or if the assessing officer is not satisfied, he will issue notice under section 143(2) and make the assessment under section 143(3). And thereafter 144, if it does not appear, then summary assessment. So, my lord, it's not so that 139, subject to what your lordship has observed, my lord, on that I have no, my lord, I have no reply that why the legislature has not included in 4C 1026 also. The legislature could very well have included section 1026 also in section 4C.
No.
And could have said.
Let us take 1026 out of the picture. What is the solution to the problem that you specified? That your income is 10 crore, but still you do not file a return, perceiving your income to be below 2.5 lakh. In such a situation,
then
how does the department proceed against you?
Well, in such a situation,
yes,
the 142 first is 142(1).
And is there any time limit for 142(1)?
No, there is no time limit for 142(1), but a time limit has to be read in the light of section 143 and 147. As you also aware, my lord, in the other cases also where the revision.
Let us see 147. Let us see 147. What is the time limit?
147. 148 you also will see.
140?
151 is the time. 49.
149.
My lord.
Where is the block assessment?
Well, that is in the case of the seizure only, you know?
Yes.
So, you also see the first part. In normal case, no notice under section 148 shall be issued for the relevant assessment year if 3 years have escaped from the end of the relevant assessment year, unless the case falls in clause B. Now, B, 3 years, but not more than 10 years have elapsed from the end of the relevant assessment year, unless the assessing officer has in possession books of account or other documents or evidence which reveal that the income chargeable to tax represented in the form of an asset expenditure so and so, provided that no notice under section 148 shall be issued at any time in the case for which relevant assessment year beginning on after the date 221, a notice under section 148, these are procedural matters. So the time limit for issuance of the notice under section 148 has been prescribed in 149.
In this case, when was the notice issued? For 2013-14, financial year 2013-14, the notice was issued on
Okay, reply this.
22/3.
the notice was issued on 27/3/2021. So that is less than 3 years.
This is the assessment year is, I think, 2000's assessment is 2013-14.
13-14, it was issued in 21. So it will be covered by B.
B, if it falls in B, well, that questions I'm not, in this case, well, in my humble submission, I'm not, while the friend said on mutual fund and all those things, these are all the discretion of the assessing officer. Let him decide whether mutual fund will fall in not, whether the limitation period is there or not, that the assessing officer will decide. At present, the issue which is there before Lordship is that, in my humble submission, one, whether 139(1) return is compulsory for the person who are exempted under Section 2026.
No, it is not. No, it is not compulsory.
So secondly, the 147, the satisfaction which is arrived at is only for the reason that the return has not been submitted. So unless and until the assessing officer comes to a prima facie conclusion, I am not saying final conclusion, a prima facie conclusion that yes, this income has chargeable tax had escaped assessment, proceeding cannot be undertaken. That's why, I submitted for your Lordship on the last date, that these assessments, whatever are there, that may be set aside. The Lordship may direct the assessing officer to issue a notice, and we will not raise the question of, in this present case, your Lordship may record it, that 148, whatever notice is there, we are not going to raise the issue of
limitation.
The limitation, at least particularly in this case. In the other cases, whatever is there, we will raise the objection of the limitation, etc. But since the Lordship is deciding the issue, we will not take advantage of that one. First of all, he should issue a notice, verify it, that whether these are income exempted or not exempted. And if you find that no,
so
these
therefore,
are not
what you say is that he will issue a notice under 142(1), whereupon he will file a return, and thereafter law will take its own.
No, I will not file the return.
Then
I will not file 142(1). Your Lordship see 142(1) again. Once your Lordship is filed, see 142(1).
142(1).
Only one, your Lordship. I'm just trying to, Lordship may not take it, that I am trying to avoid it. I'm just trying to myself try to understand. For the purpose of making an assessment under the Act, the assessing officer may serve on the person who has made a return on Section 4, or in whose case the time allowed under Section 139(1) for furnishing the return is expired. Now, if 139 is not applicable in my case, then where is the question of falling in the second part? Second part will come into operation only when I am liable to file the return, but my time limit has expired. I am submitting that under 139, I am not liable to file the return at all. So, he may, 142, second part, he may call for the information that these are informations are needed for verification, that whether income is there. I will furnish the information. Whatever submissions are there on that, he can, I try to satisfy him that these are exempted. If he is not satisfied, he may record that on this basis, according to me, the income has escaped assessment for this reason, and may initiate the proceedings.
Very well, very well. Before we even put it to the department, what is your answer for the problem that you indicated? That, let us say, forget 1026. That I have earned 10 crore, but I have not filed a return. What will the assessing officer do?
My lord, that with due respect to your Lordship, my lord, under the Income Tax Act taxing statute, my lord, not 10 crores, 100 crores are there, but the person has not filed the return. If the information comes, he can do it. If the information doesn't come, then otherwise, my lord, you'll also find 2 crores person, 3 crores person out of 140 crores, my lord, are filing the returns. And that too, my lord, you'll also find there are only 20,000 persons who have shown their income to be above 1 crore. One by-lane of road of the Bombay will be income from more than 1 crore. So, my lord, there is no answer to that question, my lord.
No, but there is also, Dr. Saraf, there is also an obligation of the court to not interpret a statute or a provision in such manner that it leads to mischief.
Yes, sir. Well, I will
to construe a provision, because we still haven't got an answer to the fundamental query that we've put, that how can you, on your own basis, otherwise we'll have to fall back on the Tripura judgment, that for every exemption, you have to require an exemption certificate.
I'll submit this. This is the schedule type 197. You may say that no, before claiming exemption 197.
Dr. Muzika, it does not hurt you too much over here. We will say that, we are setting aside all this, and we will record that he is not taking the question of limitation. And then we will say that you will take appropriate steps under section 142 of the Income Tax Act and not say anything else, because he may be right in one, Mr. Kumar's interpretation of this 142.1 may not be appropriate, because that or over there, if you read it again, will appear to be disjunctive. It's not as if he has filed previously and subsequently has not filed. It is or whose time, or this or will take if you've never filed or if you have not filed this time also. It will not, there's no distinction made between previously filed or not. And then what he says is that if it is my case that I was not liable to file under 139(1), then in that case you don't have the authority to ask me to file a return till such time that you go through, you can resort to II, which is to produce or cause such accounts or documents as you may require. After resorting to II, then you may issue the notice under 147. But you cannot bypass 142 and go to 147.
My Lord, in my humble submission, my Lord, if Dr. Saraf is saying that he is not required to file return, so 142 cannot be invoked against us, against them, my Lord. That itself answers that if the reason why we have not proceeded against under 142, my Lord, we proceeded against
I'm not saying that
under 148.
I'm not said.
He is not saying that.
142 income tax return. I'm not saying 142 itself cannot be invoked. I'm saying that you cannot direct me.
You cannot direct him to file a return.
Second part, you
No, my Lord, the scheme of the Act, my Lord, there are four types of assessment, my Lord. One is regular assessment, my Lord. One is scrutiny assessment, one is best judgment assessment, and one is income escaping assessment, my Lord. My Lord, 143 covers the scrutiny assessment, my Lord. The scheme of the Act. Now,
no, 143 will not be applicable over here. 143 will be applicable only after a return is filed in terms of 142.
My Lord.
But a return, when I claim exemption under 139(1) by virtue of 1026,
my Lord,
and says 4 capital C,
my Lord,
subsection 4 capital C, does not oblige me notwithstanding exemption,
my Lord,
then I may not be a person who is liable to file return under 139(1). In such a scenario, you cannot force me to file a return without making an inquiry under clause 2 or the other provisions. You can resort to II, you can resort to III, and after this, if you find that there is reason to believe, then you can resort to 147 and proceed.
Otherwise, what will happen, if this interpretation what you is not given, that tomorrow the computerized notice on 142.1 will be issued to all the scheduled tribes, you submit the return, then again the same thing.
If I'm allowed, Your Honor, as my learned brother has insisted for 139(4)(c), I may request, Your Honor, 139(4)(c) is explicitly written, Your Honor, that yes, unless you file return of income, the exemption provided will not be allowed to you, which is not explicitly written in 139(1), can be implicit also, Your Honor. As Your Honor, as I say, 139(1) can be seen, Your Honor. May I draw your attention? 139A says company and firm. It is mandatory written that every company and firm has to file the return of income every year. 139(1), I just take, Your Honor. Your Honor, the provision provided that every company or a firm shall furnish on or before the due date a return in respect of its income loss in every year previous year. Though it is mentioned here every person, which includes being a company or firm, but is still specifically written here, Your Honor, that by virtue of this, it has become mandatory for them to file return of income. By taking the same logic, Your Honor, 139(4)(c) emphasizes explicitly that they have to file return of income. But 1026 also draws the same inspiration as it is written in 139(4)(c) of.
See, the wording in 139,
Yes, Your
wording in 139(1)(b) is total income.
Yes, Your
Please read
Honor.
that.
Total.
Being a person other than a company or firm,
Yes, sir.
if his total income,
Yes, sir.
forget liable for other, if his total income
Yes, sir.
exceeded the maximum amount which is not chargeable to income tax.
Yes, Your Honor.
The definition of total income
Yes, Your Honor.
includes the exemption under 1026. Definition under total income includes exemption under 1026.
My learned brothers is arguing the same, Your Honor.
No, we are telling you, we are also agreeing that.
Yes, Your Honor.
1026 come to total income definition.
Yes, Your Honor.
The definition of total income will include 1026.
245.
245.
245.
Total income is 245, Your Honor.
Total income means the total amount of income referred to in section 5 computed in the manner. Now,
Yes.
section 5,
Yes, sir.
Section 10 below that will.
Section 5. Subject to the provision of this Act, the total income of any previous year who is resident includes all income from whatever source derived.
Section 10 below.
Derived?
It's saying computing the total income, this will not be excluded. You also say section 10 below.
yes. And then 10,
So, Your Honor, have seen the gone through section.
in computing the total income of previous year, any income falling within any of the following clauses shall not be included. So therefore, the entirety of 1026 is excluded from total income.
But, Your Honor, I just take your attention. Even then, 139(4)(c) says that such income, even if it is not included.
Let's not get distracted by 139(4)(c). 139(4)(c) has no impact over here.
My learned brother has been placing before
No,
Your
let's
Honor.
not get distracted by that. 139(4)(c) has no impact. We are on a simple question. I claim that my total income is completely exempted.
1023(c), sir. Take an example, 1020.
1023 is in respect of trusts and other bodies and things like that.
Provided, Your Honor.
Yes, but 1023C has an exception of 139(4) capital C.
That's right, Your Honor. That's why I'm.
Do not distract yourself with
Yes,
that.
okay.
Let us confine ourselves to a normal person who is not entitled to exemption.
Yes, sir.
Now, I perceive that my income, whatever actually may have been, is not chargeable to tax, and I don't file a return. What is your remedy? What can you do?
If you don't file, if a particular person has not filed a return of income, I will see what information I have in. First, I have to have information that your income is exceeding the not chargeable limit. Then only I can take any action under this Act, Your Honor.
And under what provision will you take action against him?
Either 142(1). If he has not filed and I have information, then 148, if I have a reason to believe.
Now, in respect of a person who claims that his total income is exempt,
How will he claim, sir? Return of income is a self-disclosure. In honor of the natural principle of natural justice, the authority has been given, responsibility has been given to
well,
the
we
assessee.
understand that,
Yes, Your
but does that mean that every person
Yes, Your Honor.
has perforce to file a return?
Of course not, Your Honor.
Then
But return of income is only a principle of natural justice, self-disclosure. My income is 10 crore, but I am exempted under section 1026. That is why I am not taxable. That is why, Your Honor, I am pressing, my prayer is before Your Honor that If somebody has to claim may be claim only in the form of return of income. That is a self-disclosure. That's why my prayer, Your Honor, stands before you.
No, 139 is not worded like that. 139 is worded by taking into account exemption. 139 could have been worded differently, where it would have said that notwithstanding any exemption, when your income, total income, exceeds the income which is not chargeable to tax, then you will file a return. But 139 is not worded that way. 139 is worded that when your total income without providing for section 10. So when you read total income, you must exclude the total income from the total income what is exempted.
Your Honor, as you are saying that your income is 10 crore, how do we judge? That's why I'm saying that return of income is only a selfless.
What you are pointing out, what you are saying, sir.
Yes, Your Honor.
You are adding to his argument. What you are pointing out is a lacuna in the provision. And the lacuna in the provision is not something that we can cure.
My placement, Your Honor, that if it is not explicit, it has to be understood implicit also. And we have to see the intention of the legislature.
In a taxing statute, you don't do things like that.
Yes, Your Honor, I have a Supreme Court judgment.
Those are things that Dr. Modica will do. We don't want all this from you. We just want the.
Yes,
Your Honor.
I don't think it is.
I just submitted yesterday. I referred
But
to
what you can do is, you can stop us from going into these considerations by arguing an alternative remedy. Because over here we are convinced there is mischief. And therefore, an alternative remedy, we will not look at it. Let him go fend for himself.
Yes, sir. Your Honor, I am saying there are, if you have a fourth son, if a father has 4 sons, 3 sons are obedient and disciplined. One is not disciplined. 1026, every person, every tribal they have. But many of them are filing return of income by showing 1026 exemption. They are enjoying the benefit. They are disciplined. They should be given. They should be awarded. But when the taxpayer, when my son is not disciplined, how can we make it discipline? How can we give the benefit of which is already given? That's my only prayer, Your Honor.
Yes, you can do the alternative remedy argument. Because all these are very old matters which have come, very old orders which have been challenged. What are the dates of the orders?
Dates are recent, orders are recent, my lord. 21.
Orders are recent.
Orders are recent, my lord.
But they have not availed of alternative remedy. Against this, what is the remedy, usual remedy?
They should have filed appeal, Your Honor.
No, we are asking him.
Please.
Yes.
So, my lord, but the other aspect, my lord, which I referred to yesterday, it appears, my lord, the proposition that 1026 income has to be excluded while computing the total income, my lord. And in conjunction with 4C, it appears, my lord, but and proviso, my lord, which I referred to yesterday, my lord, that if though exempted or not required to file under 139(1)(b), my lord.
That came in 2018.
For 21, my lord. At least for future, my lord.
For future, all right. But in 2013-14, it was not.
It was not there, my lord.
It was not there.
My lord. My lord, to that my answer will be, my lord, a normal filing of return under 139 and filing of a return under 148 notice, my lord, those will operate in different scenario, my lord. Once a notice has been issued under 148, my lord, then they cannot take the plea of 139 that they are not required to file return, my lord.
In 148, you have to indicate reason to believe.
Yes. My lord, that is one aspect, but that is not the pleaded case, my lord. In this, the reply they have given, my lord, the simple case set forth by them was that I am 1026, I am not required to file return. This is the simple and one-liner answer given by them, my lord. Even in the present writ petition, my lord, though Dr. Saraf was going beyond the pleadings, my lord, and beyond the case, their case was very confined, my lord, that being 1026, I am not required to file return. 140, or whether satisfaction was recorded, not recorded, 142 notice would have been issued, 148 could not have been invoked. These are not the plea taken, my lord, nor there are pleadings in the present writ petition to that effect, my lord.
These are the facets of the same question, and Mr. Mojika, Dr. Mojika has already went in even the notice the court is arguing now, taking the plea that this is specifically not mentioned, taking the case also that he is scheduled tribe. That is also, you must consider that he is also a scheduled tribe, not like a person who is a big businessman and has a big lawyers and etc. to do the chartered accountant and all those things. All these things have to be considered. You are penalizing a scheduled tribe that you comply with. He is not aware of the.
No. Don't get politics and emotion into this. A crook is a crook, whether he is a scheduled tribe or not. All right. So don't get politics and emotion over here. We are convinced that this is a crook, and therefore we will not allow our machinery to be befooled in this manner.
Absolutely, Lordship, Your Lordship, I would like to answer one question of Mr. Chief Commissioner.
Well, if I may conclude, my lord.
No, just a minute, Lord. Just a minute, Mr. Mojika.
I was in the middle of something. So
let him complete. You'll get a chance, Dr. Saraf. Yes.
So, my lord, filing and non-filing of return under 139 suo motu, my lord, that is one aspect of the matter. That, if your lordships come to that conclusion that yes, because of total income's definition, they may not be required to file under, or they are under no compulsion to file return, till they fall under
anything. Please come to provision. We are not doing anything beyond the provision.
My lord.
We remember this is a taxing statute.
My lord.
We remember that our limitations are very, very, very deep. Over here, we have to go by the wording of the provision.
So, my lord,
the provision says,
my lord,
one could have said
my lord,
that the total income used in the provision in the context will not be read with 1026, will not be read with exemption provision. But that you cannot say anymore because 4C has been introduced.
So, my lord, even if we accept this proposition, my lord, the second question will come, maybe normally in normal course, he or she is not required to file a return. But if he or she falls within any of the 7 parameters, my lord, the 7th proviso, my lord, then
that 7th proviso was not there in 2013-14.
That point of time it was not there, my lord, but at least some observation from lordship that this will apply in future.
No advance ruling, but we have to test your matter on the basis of the notice you issued and the procedure you've adopted. Future we'll look at later.
My lord, that was the second limb of my argument, my lord. And third argument is that, my lord, even if somebody may not be under compulsion to file a return under 139, my lord, but once a notice has been issued under 148, then they cannot take the plea that they are not required to file return under 139, my lord.
Let us see the provision,
my lord.
But then you have to satisfy reason to believe.
Reason to believe, my lord.
Then you have to satisfy reason to believe. And then you're diluting the difference that we were trying to make between reason to believe when return not filed and reason to believe when previous assessment has taken place.
My humble submission, that distinction will still remain, my lord. Even if, because this is one aspect of reason to believe exists or does not exist, my lord. The second aspect, that maybe under 139 may not be required to file a return, my lord, but once a notice has been issued.
But that has to be only if you have reason to believe. That all the 148, all of that, it hinges on reason to believe. And your reason to believe only indicates quantum of income, but nothing about escaping assessment.
In my respectful submission, my lord, that is a plea beyond the scope of the present writ petition, my lord. Nothing has been pleaded, even one sentence on that, my lord.
Dr. Mozika,
my lord,
if we were to take
my lord,
matters on the basis of pleadings,
of course,
throw out half of them.
My lord.
Your standards are very poor, our standards are equally poor. Not most of you are qualified to be lawyers, not most of us are qualified to be judges. Particularly taking specialized matters. So, there if you go into pleadings and lack of pleadings, we are very liberal.
So,
we are very liberal on that.
My lord, I leave that, my lord, that aspect, my lord.
Because at the end of the day, we can mold the relief.
My lord.
At the end of the day, hearing has not been concluded, we can say file a supplementary affidavit, take those points.
That's true.
It's cured.
Of course, I can't improve much also because the reasons that has been recorded, my lord, that
Because
is
you have to confine yourselves to what is evident from the order and the steps that you have taken.
And the reasons recorded is reflected in the order itself, my lord, page 38, my lord. Lots of seen that.
I think the better would be the alternative remedy. Try see if that alternative remedy, if he does not have any reply, then alternative remedy can nail him.
My lord.
CIT alternative assessee had the yes. Appeal.
This, unless Dr. Muzika leaves, you cannot. We on particular provision we allowed you, but this, if he leaves his brief and goes, you can.
CIT.
246. $246, my lord. Appeals.
246. Very good.
246A, capital A, my lord. I'm sorry. 246, capital A.
These orders have been passed under 148.
147, my lord.
147? 7. Very good. 148 is, of course, the notice. 246A. Capital A?
Capital A, my lord.
Yes.
It says, my lord, any SSC or any director or any collector aggrieved by any of the following orders, whether made before or after the appointed day, may appeal to the Commissioner of Appeals against
B.
It was B, my lord, an order of assessment, reassessment or recomputation under section 147.
External order passed in pursuance of directions of
Dispute resolution panel,
panel. So B is clearly.
my lord.
Is there a time limit?
There is a time limit.
And is there a provision for condonation?
Yes. Yes.
Is it unlimited condonation?
The period is not provided.
It's unlimited condonation.
And there's 264.
264 is revisional possible.
Are they parallel proceedings, Dr. Saraf?
My lord.
Are they alternative? Can you invoke 246A and 263 in the alternative?
No.
Well, in the alternative, you can also be aware, 246 is the appeal and 264 is the revision.
Yes.
You'll also be able to appeal, the entire things are opened
up. Revision is very limited.
Revision is limited, is only at the question, which is of the legality is there. Otherwise, my lord, the other questions cannot be raised in the 264.
Why don't we push you to 246A appeal?
Well, I will submit.
And leave all questions unanswered.
Well, surely I will answer in the short, my lord. My lord, the basic issue which has been raised in the petition is that whether the petitioner is liable to file the return on Section 139 or not. Because the assessment order, also you'll also find the reasons are only on the ground that he has not submitted the return. And 148 order has also proceeded on the basis that he has not submitted the return. There is no appeal you also find that under section 142(1) direction for filing the return, or whether a person has filed the return, liable to file the return or not, against that there is no appeal. Now 148, when the order is challenged in appeal, the assessing authority, the appellate authority will not decide whether he was liable to file the return under 139(1) or not. That is not a appellate order. Appellate order.
Why not? Why not? Why not?
You see the orders. The orders which are there, which can be challenged, is that 148, 147 order.
Yes. If you say that it is without jurisdiction, it can always be challenged in appeal.
Yes. Look, that I can challenge before lordship when I say that the order is without jurisdiction.
No. In an appeal, everything can be. In an appeal, everything can be done. Yes. We'll give you liberty to raise all issues.
Well, there are 226 powers which are there before lordship, as you are aware, I do not.
No, we are aware of that. But 226 is also, there's a discretion and there's self-restraint.
Absolutely.
The self-restraint is when an order is amenable to an appeal, we will not entertain it. And when an order is amenable to appeal, then every aspect of that order, from the making of the order to the foundation of that order being made, can be questioned. That I will not accept.
I will submit in this. Your lordship may certainly I'm nothing saying that your lordship is actually your lordship will be the final words. But I am only trying to
No, Dr. Saraf, we are not so conceited. We are the final word. We are in one corner of the country. Final word is in Delhi.
No. Well, I've seen your lordship segments in Madras also, and I am aware about your lordships. And yesterday also about the coal matter. I am just I am aware. This is not the platform. That's why I am not saying. Otherwise, I have great respect. What I am submitting for lordship that the basic structure of the Constitution, the 226. Now, alternate remedy, appeal.
Yes.
By 226 Constitution, the powers have been given. Now, as you also aware, the self-restraint, I fully agree with the self-restraint that should be there. But whenever the order is found to be violating both the natural justice or are without jurisdiction, or the court in one of the Supreme Court cases, the court has said that
the authority for such purpose is 1998, I think, volume SCC, volume 1, page 1, which is that.
Chabil Das.
In one judgment only.
Intellectual property matter.
Well, one judgment only, the words which have been used by the apex court is that, when the citizen's ability or jurisdiction should be dispel any doubt which the citizen had against a high-handed, palpably illegal order passed by an authority.
We cannot say this is a palpably illegal order. We cannot say this is a palpably illegal order. It is exactly like, as you know, Dr. Saraf, both. It's like Order 7, Rule 11 of the Civil Procedure Code, or the same grounds on which you can quash an FIR.
Lordship makes one thing all, I thought lordship consideration, I am making my submission only for lordship consideration, which I am aware lordship will certainly consider the presently these submissions, lordship is aware that the 226 power, when the pure questions of law have been raised in the writ petition, in spite of the alternate remedy, the apex court has said, that the alternate remedy cannot be a ground for throwing out the writ petition on the ground of alternate remedy. Now, if your lordship may just consider, one thing I make a submission, your lordship has seen, certain statutes made a provision that 226, no person can be filing writ petition, etc., in the act itself. Now, the court said, no, 226 power cannot be taken away by any statute, because this is a basic structure of the Constitution. Now, in case in the statute, an alternate remedy is provided and only on that ground, the 226 powers cannot be exercised, then, in my humble submission, the variable 226 powers which have been given to your lordship will be extraordinary power. I fully aware, that the self-restraint and in the case where the lordship finds that various facts, etc., to examine and etc., your lordship delegates him to the appellate authority. But, my lord, in a case where the very question of issuance of the notice under section 139(1) is under subject matter of challenge before your lordship, and having, my lord, your lordship also aware, my lord, when the matter had been heard at length, the preliminary objection, if it was raised at the very beginning that no, there was alternative remedy, your lordship may not entertain the petition at all. After making all the arguments, when they find that, my lord, the other arguments are all going, then they say that no, you go to the appeal. In my humble submission, my lord, that also your lordship, I will not, my lord, remind your lordship is much conversation, my lord, that when the matter is heard at length, and that last page, if somebody raises a preliminary objection about the alternative body, that cannot be retained.
No. This argument had been made from the beginning. If there's any fault, the fault lies in us, not in the department.
No fault.
The fault lies with us. The fault does not lie with the department. They had always made this argument of this being amenable to appeal, but we wanted to hear it. So that is not a complete answer.
Well,
and that would be a case, sir, where your alternative remedy has been exhausted as a result of the lapse of time. Now here your alternative remedy has not been exhausted, and we'll make an observation that the appeal will be taken up since the matter was pending for substantial period of time. We cannot use section 14. But we will say that the appeal will be taken up without undue thing to the time spent or the delay, if any. Don't take a point of. If you can say that you won't take a point of delay, I'll also record that. Because if you take a point of delay, they come next day, we'll set it aside.
Well,
it cannot be that he will not have any remedy. He has to have a remedy somewhere, a remedy on merits.
I am duty bound to accept whatever it comes. I have to accept it graciously without whatever comes from the law.
Thank you so much.
But my humble submission again will be there before lordship. If your lordship permit me, I may place one judgment.
Yes, definitely.
2023 SCC online SC 95. I've sent 2023.
Yes.
SC online SC 95.
695.
95 million only.
Yes. Do we have a copy?
Well, I've sent by mail because only after hearing Mr. Mojika, because
yes.
I thought the alternative was so.
but now this aspect has been taken care, my lord, by introducing seventh proviso, my lord, to some extent.
Which one?
I'm not.
The relevant is a slightly different, my lord, but no. Because once there is
whether he will go now, of course, he is bound, but whether he will go scot-free for the previous, that is the thing.
But that is where, my lord,
I'm not.
Exemption under maybe 139 will not apply to 148.
Please place what you want to place, Dr. Muzika, Dr. Saraf.
Well, I'm not. I don't want to be scot-free, my lord. I'm explaining, lordship, my lord. I want, my lord, that I will produce. I will explain everything. This is only question of the jurisdiction. I'm not saying, my lord, that you exempt me, I will run away. No, not at all. That's why at the very beginning I'm submitting to lordship, my lord, that let them submit, give me written notice. I will produce all the documents.
Yes.
Let them be certified.
We've got the judgment. Page 695. Page 695 or 95?
95, 95.
Oh, 95. Where?
Right, I will start with the paragraph, my lord, 3 or 4, my lord, 4. May I read, my lord, para 4?
This not maintainable aspect, since this is
No,
an
no, it-
author's judgment, this not maintainable aspect is covered in at least 250 of my judgments.
Yes.
Well, actually, your lordship judgment, my lord, what I can do, my lord, the problem is that, my lord, and with due respect to your lordship, I must say, my lord, there is no consistency in the judgment of the Supreme Court. I must say, my lord, I cannot say, my lord,
Yes.
official here, but every day I am finding, my lord, in the evening one judgment and next day another judgment, my lord, with due respect. That's why, my lord, I may, if your lordship permit me, 1-2 sentences I may say, my lord. If your lordship doesn't take it otherwise, my lord, I may say, if your lordship give me permission, then only I will say, my lord.
Yes, good. 4 is old hat. 4 is nothing new. 4 is, reminding the 7 court judgments contrary to 4. 4 is old hat,
No,
yes.
I will also say, what that is also say that para 6,
6.
no, no.
Yes,
At the end.
referring to Whirlpool, page 1.
After also say
Whirlpool, which is referred to over here.
My lord, your lordship, these are all, my lord. After also see that part we will also refer to the decision of the so-and-so court referred to so-and-so, not required, my lord, controversy. Your lordship, only I will take your lordship to something, my lord. 2000 judgment has also been referred to, my lord.
Wholly without jurisdiction, which is covered by the third limb of Whirlpool, wholly without jurisdiction will be when small causes court takes up arbitration matter. Wholly without jurisdiction is not an arguable case of jurisdiction.
My lord, para 8, my lord, because
Yes.
my lord, after all, my lord, the judgments of the apex were
While appeals preliminary or formal decision is that whether certain time interest is
what appears in the ring of the
investigation
that and maintain the case
in its discretion, even though the alternative
in its that may be well, no?
All right, we recognize this, yes.
My submission before lordship is that, my lord, that here in the writ petition, my lord, the pure question of law has been raised, my lord, only. And the question which, my lord, the subject to, my lord, again with the repetition subject sake of
Please come to 1, 2, 3, 4 of Whirlpool where pure question of law is exempted.
My lord, Whirlpool says about the 3. But as your lordship is aware, the Whirlpool has been considered and the apex court gives certain findings. Then in my humble submission, my lord, the Whirlpool, my lord,
at the end of the day, we do not want to exercise discretion in favor of such a petitioner. No, we have that choice.
That is absolutely the lordship's discretion is always good.
We don't want to exercise. When discretion has to be exercised, it has to be exercised when we are morally satisfied, not when we are question the morality of the petitioner. No.
In this case, how the Lord, my immoral, I am submitting for lordship that, my lord, I will produce the documents, papers, you verify.
No, sir.
Otherwise, my lord, one submission I will make, my lord. One submission, subject to, I will complete my arguments and leave it on lordship, my lord.
Yes,
my
sir.
learned friend, Chief Commissioner said in a family, 3 persons are there and they are filing the returns and 1 person is not filing the returns, the tribal persons. In a country of 140 crores, 3 crore people are filing the returns. What happened to the 50 crores? What moral duty is there?
Dr. Saraf, you are an experienced lawyer. You should not, fall for that. Those are no arguments for us. Before us, those are no arguments.
I am submitting, my lord, that it's not so. When the Act says, if, my lord, your lordship can iron out the creases but cannot alter the materials of which the cloth is woven, the legislature ultimately is intentionally, if the puts in the static book, that this is the provision, in my humble submission, my lord, that words have to be used, neither the income tax department nor any department can go beyond the statute.
Thank you.
The legislative intent in the taxing statute is to be gathered by the words used in the statute, and that intention cannot be gathered on the basis of the general knowledge or the general feeling of the department. But this is my humble submission. Again, my Lord, I will with following hand, I will pray before Lordship, my Lord, that since the question involves the pure question of law, your Lordship may decide the question of law, thereafter send the matter back to the assessing officer, because that will be, my Lord, in my humble submission.
Thank you. We'll record that. We'll record that. We'll duly record. Thank you so much, Dr. Saraf.
I'm obliged, Lord.
The writ petition in this case.
May you Lordship permit me, Lord?
Yes, definitely.
I will leave for the High Court.
Definitely.
I'm grateful to your Lordship, Lord.
Thank you, Dr. Saraf. Thank you. The writ petition questions the propriety of several orders passed against the writ petitioner under section 147 of the Income Tax Act 1961 pertaining to several financial years beginning pertaining to several assessment years beginning AY 2013-14. Full stop. Paragraph. The impugned orders were passed around the same time in and about March 2022. This petition under Article 226 of the Constitution was carried to this court shortly thereafter, in April, by the end of April 2022. Full stop. The principal issue raised by the writ petitioner is that the writ petitioner, being the member of a scheduled tribe and deriving income exclusively within a notified area, was entitled to the full exemption of income under section 10(26) of the Act, and as such, not obliged to file any return of income under section 139(1) of the Act. Full stop. Paragraph. Some essential facts need to be noticed for the limited purpose of adjudication involved herein. Full stop. The petitioner received the petitioner received a notice under section 148 of the Act on or about March 27, 2021, by which the assessing officer wanted the petitioner to indicate why proceedings should not be initiated in terms of section 147 of the Act. For the petitioner not having filed the return of income for AY 2013-14 within the stipulated time. Paragraph. The reasons recorded under section 148(2) of the Act indicated that information gathered by the assessing officer revealed that the writ petitioner had paid in excess of rupees 7.74 crore for purchase of mutual funds and had high value banking transactions or deposits in excess of rupees 30 lakh, totaling to transactions in excess of rupees 8.05 crore. Full stop. The assessing officer went on to record that despite such huge transactions, the writ petitioner had not filed any return of income, and the assessing officer had reason to believe that the income of the writ petitioner chargeable to tax had escaped assessment for the relevant assessment year. The assessing officer asserted that the escapement was on account of the omission or failure on the part of the writ petitioner herein to fully disclose material facts necessary for the purpose of assessment. Full stop. Paragraph. The writ petitioner did not respond to the notice of March 27, 2021, and the matter was taken up for scrutiny assessment in terms of section 147 of the Act, read with section 144 and 142(1) thereof. Full stop. Read with section 144 of the Act. Full stop. A notice was issued under section 142(1) of the Act on July 12, 2021, requiring the petitioner to submit her response with supporting documents on or before July 28, 2021. Full stop. Despite due receipt of such notice, no response emanated from the writ petitioner. Full stop. Paragraph. The matter was thereafter transferred to the Regional Faceless Assessment Center, RFAC, under the Faceless Assessment Scheme, 2019, and a detailed questionnaire was issued to the petitioner in December 2021. Full stop. Despite due receipt of such questionnaire, the writ petitioner did not respond thereto. Full stop. A further notice was issued under section 142(1) on January 5, 2022 and served on the petitioner, but the petitioner ignored the same. It was only after a subsequent notice was physically served on the SSC and a show cause notice under section 144 of the Act was issued that the petitioner furnished, on February 3, 2022, a copy of an Indian Oil Corporation Limited LPG distributorship letter of intent of June 16, 1989, a certificate of importer-exporter code, a caste cum residency certificate, and nothing else. Full stop. A further notice ensued under section 142(1) of the Act, which expressly provided the following, next line, open quote, your eligibility for exemption of income can be considered only on filing your return of income and other relevant information along with supporting evidences to justifying (SIC) italics your claim, full stop, close quote. Paragraph. The writ petitioner then responded by informing the assessing officer that an investment in mutual funds had been made from a certain ICICI bank account full stop. She also indicated that she was an authorized distributor of LPG gas cylinder functioning in Nongstoin and dealt with coal and limestone export at Borsara in Meghalaya. Full stop. The petitioner also furnished details of 5 bank accounts that she maintained. Full stop. In addition, the writ petitioner claimed that she was a Khasi scheduled tribe, that she belonged to the Khasi scheduled tribe and was a resident of Shillong, and her income arose only in Meghalaya, which is a 6th scheduled state. She asserted that she did not file any return of income for AY 2013-14 as, open quote, the same is exempted from income tax under section 10(26), close quote, full stop. She forwarded her scheduled tribe certificate along with her reply and indicated that she did not maintain any books of account. Full stop. She, however, offered to furnish her bank account statements, but suggested that since such records were voluminous, it was not convenient to append the same with her reply. Full stop. On the basis of such material, before the relevant authority, an order came to be made on March 22, 2022, finding that the writ petitioner herein was liable to pay a huge amount by way of income tax. Full stop. Paragraph. In similar circumstances, the income of the petitioner for several other assessment years were also taken up for consideration, and orders passed under section 147 of the Act on similar lines. Paragraph. At the outset, when this writ petition was received, and even at the time that several adjournments were obtained by the petitioner, a submission had been consistently made on behalf of the department to the effect that the orders impugned were amenable to appeal, and as such, this court should not entertain the petition under Article 226 of the Constitution. Full stop. However, since it was submitted on behalf of the petitioner that a pure question of law was involved, the matter languished and was ultimately taken up for consideration of the relevant question of law. Full stop. Paragraph. According to the petitioner, the orders impugned are liable to be set aside as being completely without jurisdiction. Full stop. The petitioner asserts that in view of the definition of total income in section 10(45) of the Act and the wording of section 1026 of the Act, once a person perceived the total income to be exempted under section 1026 of the Act, such person was not obliged to file any return under section 139(1), under section 139 of the Act. Full stop. It is pointed out on behalf of the petitioner that at the relevant point of time, section 139 had not undergone the change by which, notwithstanding any exemption under section 10 of the Act, when certain parameters were met, a person was obliged to file a return and claim exemption. Full stop. It is also pointed out on behalf of the petitioner that Section 139 bracket 4 capital C of the Act makes a distinction between persons entitled to certain kinds of exemption under Section 10 of the Act and other persons also entitled to exemption. Full stop. The petitioner submits that it is only in the cases of the person specified in Section 10, in Section 139 bracket 4 capital C of the Act, that when the total income is taken into account, notionally the exemption under Section 10 of the Act provided to such person is not taken into consideration, and the requirement of filing a return is without the exemption being considered. Full stop. Paragraph. The point that the petitioner seeks to make is that since only certain classes of exemptees under Section 10 of the Act have been obliged to file a return, subject to the total income exceeding the limit not chargeable to tax, and without taking into account the exemption granted under Section 10, other persons who were beneficiaries of the exemption provision are not required to file any return as long as they can bona fide maintain that the entirety of their total income was exempt under Section 1026 of the Act. Full stop. Paragraph. A fundamental issue is raised, but it may not be necessary, in the present context to look into the same. Full stop. If the petitioner is understood correctly, the petitioner must be seen to suggest that where an exemptee under Section 1026 of the Act perceives the entire income accrued to such person in an assessment year to be exempt by virtue of Section 1026 of the Act, Section 139(1) of the Act would not come into play for such person to be required to file a return of income. Full stop. In a sense, the petitioner seeks to suggest that as long as the relevant person is satisfied that he is not liable to pay any income tax by virtue of his total income being exempted as per his perception, he cannot be touched. Full stop. Paragraph. As a continuation of such line of reasoning, it is submitted on behalf of the petitioner that if there is any lacuna in a taxing statute, it is not for the court to bridge the same or read words into a provision that do not exist. Full stop. The petitioner insists that since the word, the expression within quote total income used in section 139(1) of the Act has to be given the same meaning as such expression has been defined in section 10(45) of the Act, comma, the perception of a person that his income is exempt is enough to not require such person to file any return of income. Full stop. Though the department seeks to suggest that a person cannot be both the judge and the jury in his own cause, and once the total income exceeds income that is not chargeable to income, chargeable to tax, such person should file a return under section 139(1) of the Act and claim the entirety of the income to be exempted, so that the department can verify the claim, the greater emphasis laid by the department is on the alternative remedy which is available to the petitioner, since a regular appeal in this case could have been carried under section 246(a) of the Act. Full stop. Paragraph. At this stage, two objections are taken on behalf of the petitioner to the effect that, ordinarily, if a preliminary issue as to whether the matter should remain in this court or the petitioner be left to pursue any other alternative remedy is concerned, such issue should be decided at the initial stage and within a few days of the institution of the matter in court, and not be a consideration available at the final hearing. Full stop. The second point made on behalf of the petitioner in such regard is by referring to a recent judgment of the Supreme Court reported at 2023 SCC Online 95 bracket Godrej Sarali Limited versus Excise and Taxing Officer, where a distinction is made between a petition not being entertained on the ground of there being an alternative remedy and a petition not being maintainable. Full stop. Paragraph. It is elementary that when a petition is not maintainable, the merits of the matter, despite the highest case in equity that may be brought by the petitioner, cannot be gone into. Full stop. However, when a defense of alternative remedy is raised, the court exercises a kind of self-restraint on itself and leaves the parties to work their remedies out before the regular forum rather than allow its grants extraordinary jurisdiction, comma, particularly under Article 226 of the Constitution, comma, to be invoked in an everyday case. Full stop. Thus, comma, it is apparent that when a plea of alternative remedy is taken to resist a petition under Article 226 of the Constitution, comma, it cannot be said that the petition is not maintainable, full stop, semicolon. However, it is a mistake that is committed by courts across the country by referring to petitions which could have been carried to an alternative forum to be described as not maintainable, comma, in a manner of loose speaking, comma, under Article 226 of the Constitution, full stop. Paragraph. However, comma, there are certain cardinal tests which are to be applied before in course of the court exercising self-restraint and requiring the parties to go to a forum, to go to the regular forum, full stop. These tests have been noticed in several decisions and, comma, quite akin to a situation under Order 7, Rule 11 of the Code of Civil Procedure 1908, and in cases where a first information report may be quashed for it not indicating the ingredients of any offence, comma, some of the tests have been comprehensively noticed in the judgment reported at AIR 1998 SC 1 bracket Whirlpool Corporation versus Registrar of Trademarks, full stop. Paragraph. Indeed, comma, the 4 criteria from Whirlpool in italics, have been set out in the judgment of Godrej SR, whatever it is, Godrej Sara Lee. Full stop. These tests are the following, colon. 1. When the writ petition seeks enforcement of any fundamental rights. 2. Where there is violation of principles of natural justice. 3. Where the order or the proceedings are wholly without jurisdiction. Semicolon or, next 4. These are Roman small 1, 2, 3, 4. Where the vice of an act is challenged. Full stop. Paragraph. It may be also added in the same breath that merely because there is an alternative remedy does not prompt a constitutional court to ask the parties before it to exhaust such remedy, comma, the court must consider whether the remedy is also efficacious, full stop. Paragraph. In a manner of speaking, comma, every matter carried to a court is for the assertion of some kind of fundamental right, full stop. However, comma, merely because a person asserts a fundamental right is no ground for such person bypassing the usual process or procedure and invoking the extraordinary jurisdiction under Article 226 of the Constitution. However, comma, when a constitutional court finds that an order has been made which is contrary to all canons of natural justice, or when an order is made wholly without jurisdiction, comma, the constitutional court would not allow the suffering of the party complaining before it to continue by sending such party to the regular forum. Full stop. Paragraph. However, comma, it is the nature of the challenge which is of importance. Full stop. In the present case, comma, the rather elongated narration at the outset was necessary to demonstrate that this cannot be a case of violation of principles of natural justice. Full stop. This was a case where an arrogant petitioner refused to comply with every request of the department to only suggest that since she belonged to a member of a scheduled tribe, she was above the law. Paragraph. This is also not a case of authority having been exercised without jurisdiction. Full stop. Notices were issued by referring to the relevant provisions. Full stop. On the face of it, such provisions permitted the exercise to be carried out in the way it was sought to be. Full stop. At any rate, comma, if the writ petitioner perceived the very notices to be without jurisdiction, comma, the writ petition ought to have challenged the authority to issue such notice at a much previous stage than taking a chance to participate in the proceedings and seeking to challenge only the outcome thereafter. Full stop. Paragraph. This case also does not involve any challenge to the vires of any provision. Full stop. There is a huge chasm between the interpretation of a provision and the challenge to a provision. Full stop. When it is a challenge to a provision, comma, a constitutional court, comma, if prima facie satisfied of an element of merit in the challenge, comma, may not relegate the parties to the usual forum, since, comma, if the appellate forum is a tribunal, comma, it may not have the authority even to go into a question of vires. Full stop. However, comma, by merely challenging the vires of a provision without there being any element of substance therein, comma, no knave can bypass the regular procedure and insist on the constitutional court to adjudicate the lists carried by him. Full stop. Paragraph. In the present case, comma, a regular appeal is maintainable and the submission on behalf of the writ petitioner to the effect that such regular appeal will be confined only to the order passed under section 147 of the Act and cannot be enlarged to look into the foundational aspects going into the making of the order, comma, cannot be countenanced. Full stop. Indeed, comma, when an appeal is of limited scope, comma, the appellate provision will expressly provide therefore, as in cases where appeals are limited to questions of law and facts are excluded. Full stop. There is no expression in the entirety of section 246 capital A of the Act to construe the power of the appellate authority to be limited only to section 147 and not take up the fundamental issue that is sought to be raised in the present proceedings. paragraph. Finally, the writ petitioner appeals to the court to exercise its discretion since the fundamental premise, since the primary premise of the argument falls within a narrow compass. Full stop. The petitioner appeals that it would be better if the question raised were to be decided and the matter left to the department for the department's further consideration. Full stop. In such connection, now in such connection, just cut it out. Full stop. Ordinarily, there is an element of bona fides which is taken into consideration by a writ court, particularly when allowing its discretion to be exercised in an extraordinary case. Full stop. Quite frankly, the conduct of the writ petitioner herein does not inspire any confidence or does not merit any discretion to be exercised in her favor. Full stop. Her income during the relevant financial year during the relevant assessment year of 2013-14 referred to above was in excess of rupees 8 crore. Full stop. All that was required of her upon receiving the several notices was to demonstrate that such income, in its entirety, was exempted under section 1026 of the Act. Full stop. Yet, notice after notice went unheeded till the respondent, till the petitioner furnished the details of her bank accounts, claimed that she had invested and reinvested in mutual funds, and glibly submitted that she maintained no accounts, despite maintaining that she was an authorized distributor of LPG gas cylinder, an exporter of coal and limestone, and the like. Full stop. Such conduct on the part of a citizen would not excite a constitutional court to exercise any discretion in her favor. Full stop. Indeed, provisions of the statute and the general availability of remedy and the considerations allowing certain remedies to be pursued may sometimes rest with the conduct of a party approaching the court or the element of prejudice suffered by such party. Full stop. In this case, neither the conduct nor the alleged prejudice suffered by the petitioner herein prompts the court to exercise any discretion to receive the matter and adjudicate the same without leaving the petitioner free to approach the regular remedy in accordance with law. paragraph. It is, however, recorded that since the matter had been pending in this court for a substantial period of time, whatever may have been the reason therefore, the department should not take a point of limitation before the appellate forum, or else, even if such objection is taken, the appellate forum deals with the objection with a degree of latitude towards the petitioner herein. Full stop. Paragraph, it is made clear that the legal issues raised have not been gone into, and it will be open to the appropriate appellate forum to decide the same in accordance with law. Paragraph WP so and so is disposed of without going into the merits thereof as aforesaid, and by leaving the petitioner free to approach the appellate forum, full stop. The latitude on the ground of delay will be exercised in the petitioner's favor if the appeal is carried within 4 weeks from date. Full stop.
But can it be 8 weeks, my lord? 8 weeks, my lord.
Paragraph. There will be no order as to cause.
Oblige.
Oblige, Your Honor.
Yes.
Second call from the main list, item number 2.
Yes, sir. How long will you take, Mr. How long will you take?
At least half an hour, my lord.
At least half an hour.
At least half an hour.
So, will you reassemble after lunch, or do you want to carry on? Whatever, your choice. We can start and finish, and or we can reassemble after lunch.
If I can start, I'll complete in half an hour, my lord.
Then start.
Son.
You are ready to finish it, Mr. Bhattacharya?
My lord, it depends upon which, but then I don't know, altogether it cannot be half an hour, my lord. Thereafter, Lordship will be dictating judgment. So there are 11 witnesses here.
Yes. He says it.
Yes, fine. It's up.
My lord.
The two matters are related.
Related, my lord.
Okay.
Related, my lord.
Then we'll take it some other day.
Some other day.
Hey. Where do you come from?
I'm from Shillong. I'm from Shillong, my sir.
Oh, we were worried that if you come from outside, then it's our obligation not to send you back. Oh, very good. So take your pick.
Any date convenient to your lordship, my lord.
25th.
25th May.
My lord.
So,
Both the matter, let the matter appear on May 25. Single bench. Yeah. Come back and take it up just now.
Deeply obliged.
From the main list, item number 1.
Supreme Court matter is over?
No, not yet, Your
My
Lordship.
Lord, it's still pending.
Very well.
My Lord, I'm appearing for the UGC in these matters, my Lord. If I may make a humble submission, my Lord.
Yes, madam.
The Supreme Court matters were scheduled to be listed on 30th of November 2022, my Lord. But since 30th of November till date, the matter has not been listed. The applicants herein means the petitioners before Your Lordship, the CMJ University, as well as the state have preferred SLPs. So, my Lord, if they could be requested to make a mention before the court and get it listed, reason being, my
Very
Lord,
well. It
only
is
one matter, only
you're for the
only
respondent.
one matter has been decided.
Very well. It
My
is
Lord, I'm for UGC. I am not in the.
You're for UGC. It is submitted
Yes,
on
ma'am.
behalf of the parties that the matter pending before the Supreme Court has not yet been taken up. Full stop. The corollary to such submission is that since this petition had waited for the Supreme Court decision, comma, it should not be taken up immediately. Paragraph. However, comma, different notes. A submission of a different note is made on behalf of the University Grants Commission, which says that the mere pendency of special leave petitions without the special leave petitioners taking any steps to prosecute the matter should not be an impediment to the present matter being considered by this court. Full stop. Paragraph. Since it appears that for several months this petition has awaited the outcome of the matters pending before the Supreme Court, comma, let this petition be adjourned for 8 weeks for the moment, full stop. It is always open, comma, both to the petitioners and to the respondents of any proceedings before any court to request the court to take up the matter expeditiously, full stop. Accordingly, comma, the respondents herein can also take appropriate steps, full stop, then give a date after 8 weeks. You tell the Supreme Court that it's because of you, High Court is not taking up, Supreme Court will list it quickly.
My Lord, actually, we are not a party in the SLP before the Honorable Supreme Court, my Lord.
Very well. You can always make an IA saying that because of this matter pending, High Court is not taking. That is done in 1 minute.
I shall advise.
Lord, the vacations are also coming up, Lord. Summer vacations also coming up. Also.
Where?
In the Supreme Court. Lord.
Oh, we don't know summer vacation here.
No, not.
Yes. Call on the next matter.
All the matters.
All the same matters. The individual orders in all the matters. Thank you.
Obliged.